Hello, I'm Bob Goulder, a contributing editor with Tax Notes. Today, we're going to take a closer look at the recent Supreme Court decisions related to President Trump's tax returns and financial records. Those cases are Trump versus Vance, which concerns a New York grand jury subpoena, and Trump versus Mazars, concerning a group of congressional subpoenas. To help us make sense of these decisions, we've enlisted the expertise of author and historian Joe Thorndike, who also happens to be a contributing editor at Tax Notes. Joe, thank you for joining us.
Hey, it's my pleasure to be here.
Joe, it's not every day that the Supreme Court of the United States takes up a case that involves presidential tax returns. This must have been exciting for you.
Well, you know, I get my excitement in strange ways, right? There's tax geeks of this world, right? And tax historians even more. But yeah, this was kind of a cool moment. It's a rare one when presidential tax returns, which are a topic that a lot of people are interested in. It makes the news once in a while, but it doesn't usually get this kind of attention, like really at this level.
Before we get into the nuts and bolts of these cases, let's talk about their procedural posture. And just to clarify, there's subpoenas for tax returns and financial statements here, but none of the subpoenas were actually issued to the president directly, correct? They were issued to third parties.
Right, and it's actually sort of interesting. So these subpoenas go to the president's bankers or to his accountants. But the president sort of jumped into these situations and said, hey, you know what? I'm actually at issue in these things. And although I'm not named in the subpoenas, they are clearly about me and they implicate my role as president. And so, in the case of the Vance case, he says, this implicates my Article 2 powers as president, and it implicates the supremacy clause, in which, the federal government is supreme over the states. In the case of the congressional subpoenas, he says this is a separation of powers issue. So although he jumps in as an individual and objects as an individual, he's injecting himself as president as well. And the claims he's making are as Donald Trump, president of the United States.
Well, it feels like a case of first impression, but in a sense, it's not, because some of these issues go way back to the early days of the Republic. If you look at the head notes of one of the opinions, they talk about the 1807 trial of Aaron Burr that implicated sitting president Thomas Jefferson. And you fast forward to the 1970s, you have litigation that's somewhat similar, implicating the sitting president Richard Nixon. And of course, more recently, President Bill Clinton in the 1990s had to sit for a deposition while in office. And those presidents all made similar claims of basically presidential immunity, and it didn't work out. So given that we have 200 plus years of adverse precedent, was it inevitable that these arguments weren't really going to fly?
Yeah, I think that it's probably fair to say that President Trump set himself by a pretty high hurdle to clear here. It's probably useful to separate the two cases out, because I think that his objection in Vance was going to be even harder to make stick than the one in the congressional case. But in Vance, he lost both these cases in the lower courts, and a number of lower courts rejected his arguments about immunity to these subpoenas. And certainly in the case of Vance, during oral arguments, the justices of the Supreme Court hinted pretty strongly that this was going to be a hard case for the president to win. So yeah, I do think this was going to be a heavy lift for him. I think that the Burr case is actually an interesting one. I'm a historian, so you'll forgive me if I latch onto your Burr thing. But the Burr case is interesting because it actually hits on some of the main arguments that Trump made in both of these cases. Burr, in this case, sues Thomas Jefferson, or is suing Thomas Jefferson, and they serve a subpoena on Jefferson looking for information. And Jefferson says, no, 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 I can't handle a subpoena because it's too demanding, right? My job is too demanding. It'll take too much time for me to answer a subpoena like this. And Chief Justice Marshall says, you know, the demands of the president are real and substantial, but they are not unremitting, he says. You know, there's time. You know, your job is hard, but it's not that hard. And in many ways, that's what people have said to Trump here, because Trump in both these cases, he's made other arguments as well, but he said, you know, oh, the demands of being president are just too much. I can't be distracted. And the courts over and over again, including the Supreme Court, has said, hey, you know what, big guy, it's first of all, we're not actually asking you to answer these subpoenas. We're asking these other people to answer these subpoenas. So, you know, your accountants. So you don't actually even have to go find your tax returns in advance. We're just asking your accountants to send them over. But they're saying, you know, it's just not that distracting. That's not a compelling argument. That argument first gets resolved in Burr, and it's been ever since then. It's been accepted that although the presidency is demanding, you can't simply say like, oh, I'm just too busy to deal. That's not legitimate, or that's not adequate to reject the demands of a subpoena. So I think yeah, you know, to go back to your original question, was Trump sort of destined to lose these? Well, no, and as we'll talk about later, he maybe didn't necessarily lose these, but I think it's pretty clear that by most definitions he lost in Vance, at least, and I think he was almost destined to lose that. There was a lot of history. There were numerous decisions that had been made over the last 200 years that suggested that this claim that he was immune from this kind of subpoena, even at the state level, a state subpoena, was just not going to hold water with the court. So.
And just briefly, how does the episode with Richard Nixon in the 1970s fit into this? Same kind of issues playing out?
Well, same sort of issues, but you know, in that case, they said that the Supreme Court unanimously decided that President Nixon was going to have to produce the Watergate tapes, which was quite burdensome on the president and quite dangerous legally for the president. And yet the court said, you are still required to answer this subpoena, and we're not going to let you off the hook on this. And the Clinton case is in terms of this question of like being too demanding, is also very relevant, because Clinton was actually required to sit for a deposition, which is really a lot more work and a lot more distracting, a lot more of an imposition on the president's time and his fulfillment of his duties than simply allowing a third party to deliver his papers. So, I mean, again, the court had decided reasonably recently, twice, that they were going to ask a lot more of presidents in terms of their responsibility to answer a subpoena. And so, you know, Trump's objection that allowing a third party to answer the subpoena was going to be too much, I mean, that was always going to be a hard sell, I think, with the justices. And again, all of this really applies to the Vance decision. The congressional subpoenas are really sort of a different animal, and the case was really made on different grounds.
Well, you hinted at this before, but let's just get straight to it. Who really won? And the reason I ask such a question that you think would be, you think the answer would be self-evident, but I'm suggesting that it's not, is that to an extent we saw the attorneys for both sides claiming a sort of victory lap. And that just confuses a lot of people. So I suppose the question as to who wins depends on how you define victory. What's your take on all that?
Well, I mean, I think there are legal ways to define victory, and then there are political ways to define victory. And I think a lot of the news coverage conflated those two, or chose one of them and focused just on that and ignored the others. So, you know, in Vance, President claims, hey, they shouldn't be able to subpoena all these documents. Well, the court said, yes, they should. And so your claim of immunity, your claim that these subpoenas are no good, well, we reject that argument. They have the right to issue these subpoenas, and in some level, you're going to have to respond to or you're going to have to allow them to be responded to by the third parties. I think it's fair to say that the president lost that case. But what happened is that, in practical terms, is that the court said, we're going to return this now to the lower court where some issues still need to be resolved. That was always what was going to happen, really, because there were still issues to be resolved. And some people said, well, this is a victory for the president because the court didn't say, hey, send over those tax returns this afternoon to the grand jury. No, they said, go finish dealing with this at the lower court. And that's going to take some time. And that will probably take more time than we have before the election. And therefore, the president was able to delay the resolution of these, the final resolution of these subpoenas. And so some people saw that delay as a victory for Trump. He managed to push this off till after the election. And I think that that's a mistake. I think that's sort of a ridiculous definition of what constitutes victory. First of all, it was never realistic to think that the court was going to say, you have to now, your accountants now have to comply with these subpoenas immediately, like this afternoon. I mean, that was never going to happen. And that it was always likely that it was going to go back to the lower court. And in any case, I'm not sure what the delay actually gets the president or doesn't get the president, because let's just say that these tax returns are quickly sent over to the court. Let's just say that the lower court resolves these issues and they say, okay, you now have to comply with the subpoenas, and all these materials are picked up, put in boxes, and sent over to the grand jury. Well, when they get there, they're going to be secret because grand jury proceedings are conducted in secret. And they actually do a pretty decent job of keeping them secret. It's possible they could be leaked or whatever. But in all likelihood, these things are going to stay secret. They were never going to be made public before the election. So the election is really a non-issue. I mean, in all likelihood. So I just don't understand why delaying these things till after the election really matters all that much. It just doesn't, that's of no consequence. I think that the way to look at Vance is that the president lost this case on the merits, and it is now going to unfold in the way that it was always going to unfold if he lost the case on the merits. So Trump loses that, I think. And I think that anyone who thought that Vance was going to result in, hey, the world's going to get to see President Trump's tax returns, that was unrealistic. It was never going to go that way. That was a misconception of what was really at stake here. So then we have the congressional cases, right? And we haven't really talked very much about those. But essentially what the court decided in the congressional cases was, all right, so you claim, President Trump, that these subpoenas are a violation of your of the separation of powers principles in the Constitution, and that they infringe upon your powers as president. And so these sorts of subpoenas are invalid. And the court said, well, that's simply not true. Congress has the right to issue subpoenas to you as president, to the executive branch, to seek your personal records as an individual, not just as president. They actually have that subpoena power. However, these particular subpoenas are not as yet going to be enforced. We think that the lower courts, which all upheld these subpoenas, did not adequately consider the separation of powers issues that are at stake here. And so we're going to send these back to the lower courts. We want them to take a new look at these subpoenas and think hard about whether or not, there are separation of powers issues here. So another delay, right? They got to go back and take another look at this. Now this delay might actually be a victory for President Trump, because if the court had said, no, these subpoenas are good to go, you got to hand over this material, and these third parties handed the material over to Congress, Congress might have made that stuff public very quickly. And these would not necessarily have been President Trump's tax returns, although those might have been part of it. They were financial records, sort of broadly defined, which could have included tax returns, but not necessarily. But Congress could have made that stuff public quite quickly, and that would have happened before the election. That could have been politically damaging. So in this case, we might want to look at this and say, well, President Trump got a delay. That's all he got. He didn't win the case. They didn't say these sorts of subpoenas are no good. They said these sorts of subpoenas need to be thought more carefully about. And that delay, that return to the lower courts and the delay, that I think we could conceive of as a political victory for the president. And legally, it's sort of a punt. It's a nobody won a clear victory. Congress won a victory in the sense that Congress retains the notional power to issue these sorts of subpoenas. The presidency won because the court affirmed that the presidency has some defense against these sorts of subpoenas, but nobody won a clear victory one way or the other. It's going to be litigated whenever it happens. That's what the court said. These are going to have to be litigated. So the courts won a victory. The Supreme Court said, we win because we're going to be the arbiters of which subpoenas are legitimate and enforceable and which ones are not. So that was a very long answer to your question. But to say, I think that the question of who won and who lost really depends on which set of goalposts you're trying to use. There are the legal goalposts. If you use legal goalposts, I think the president clearly lost in Vance, and nobody clearly won on the congressional subpoenas. I think politically, nobody really won in Vance because no one was really going to win in Vance. And I think that arguably Trump might have won in the congressional case. It's complicated because the politics are complicated. No one really knows how this plays out politically, right? We think that a delay is good for the president. It's not totally clear that delay is great for the president. He's going to keep talking about these things, you know, and it's not clear that it's useful for the president to keep talking about these sorts of things at this point. But in any case, I think that there's the winners and losers here are not so clear, and we should just be careful about jumping to conclusions about who the great political victor is in these cases.
I see. Well, you previously wrote about the oral arguments in these cases. And by the way, the oral arguments were conducted virtually due to the COVID-19 pandemic and live stream. So you were listening in. And I think you wrote at the time that just judging from the questions and the tone of the questions that the justices were presenting the attorneys with, it seemed like they were fairly comfortable with grand jury subpoenas and a bit skeptical towards the mischief that might occur with congressional subpoenas. In terms of just different branches of government, is that your take? Just that the judiciary likes subpoenas that come from the judicial branch and they're not so much from the legislative branch?
Is that cynical of me? Because I mean, because yes, is my answer to that. I think that there's some truth to that. I think that that judges are lawyers. They go to law school. They study a lot of legal cases. They study a lot of courts. They are trained to believe in the judiciary and in the legal system. And so they tend to look kindly on, I think, more kindly on subpoenas that arise from within the legal system, which seem to them like good subpoenas, like real subpoenas, as opposed to the subpoena power that's entrusted to Congress, which seems sort of like this weird, strange, not very real subpoena power. I mean, now I'm obviously attributing a lot of motivation to them that they certainly wouldn't put on paper, but I mean, I think if you look at the way people write about the subpoena power in general, they write about the congressional subpoena power like something foreign and weird and strange and not like the judicial subpoena power. And I think that the courts have validated that, you know, that and when they look at the congressional subpoena power, they see Congress, they see political parties, they see partisan interests at work, and they see things which are corruptible in a way that, you know, I think lawyers don't like to believe that the judicial system is corruptible. So I guess what I think that I'm saying is that there's a professional bias here among you know, lawyers, but especially lawyers who are working within the judicial branch, who are believers in it. And I'm just a little bit skeptical. And I just want, I wrote an article about this, and I just want to sort of like throw that red flag out there and say, institutions and the people who work within them develop a bias toward those themselves, and you know, they support themselves, they believe in themselves, and I think the judiciary does that. So in this case, I think it's just very predictable to me that a court looks over a subpoena issued by a grand jury, which is a familiar judicial instrument. And they think, yeah, grand juries, we believe in grand juries. That's right. That's like, goes back to the ancient days of the common law, like it's all, that's what all you, I'm not a lawyer, so I can say this stuff, but that's what all you lawyers did in law school, right? This brings home that warm, fuzzy days of your mid-20s. Whereas like, that's not the way people think about Congress. And Congress seems like a sort of dirty, polluted, nasty politics thing. So I mean, I don't want to make too much of this, but I do think there is something to that. And I think that's unfortunate on some level, because I wish that we saw Congress in a more rarefied way, I guess. I mean, I think it's almost charming the way that courts look at the judicial system. I wish that there was someone who felt that way about Congress. And believe me, I understand why people don't. Congress leaves me sort of disgusted with the state of American government sometimes as well. But we need to believe more in Congress. And in any case, we can't afford not to believe in Congress. Like, we can't just throw up our hands and say everything that they do is corrupt and we can't really trust it. We have to believe more in it. And we have to believe that Congress has these powers and will exercise them with responsibility. And if for some reason they don't, then we need to do something to fix Congress, because we can't just deprive Congress of its powers, of its constitutional powers, on the grounds that they will misuse them, because then we're going to create imbalances between the branches. We will necessarily aggrandize the presidency. We will aggrandize the judiciary. We will diminish the legislative branch. That's not good for American government. So I guess what I'm offering is an oral brief on behalf of the legislative branch. We have to believe in it. And if we can't, we need to reform it.
How significant do you think it is that the Chief Justice himself, John Roberts, penned these decisions? Is it fair to conclude now that he's established a tendency to take responsibility for writing the majority opinions, if they happen to be majority opinions, in cases with broader implications? I'm thinking he also wrote the majority in the case that upheld the Affordable Care Act. Am I reading too much into that, or not?
I mean, you're not the only one, right? A lot of people are saying this is truly the Roberts court now. He does seem to have established himself, maybe not as the swing vote, as one of the swing votes. I guess Justice Gorsuch has also proven to be a little bit unpredictable in the way that he's voting, and I mean that in the best sort of way. And so, but I do think that, what's striking to me about these decisions, they were not unanimous, as opposed to, say, like the Nixon decision, which was. The court in general, in these big cases that are sort of grappling with the separation of powers questions, the court does like to have unanimous decisions. They obviously couldn't get there on these two decisions. But, they did pretty well. A lot of people, I think, were expecting the sort of classic 5-4 decisions that we see a lot of these days. It was pretty impressive, I think, that they came to a 7-2 decision. Now, I think in Vance, that wasn't super surprising to a lot of people. Some people thought they might get a unanimous decision in Vance. But I think in the congressional case, it was really quite significant that you managed to get a bunch of a 7-2 decision here. You got a lot of the liberal justices, liberal justices, to sign on with some conservative justices on a decision that was not a clear win for either the liberals or the conservatives. I mean, this was sort of a classic compromise, balanced decision. This seems very Roberts-like to me. And if any decision seems like Roberts is in control to me, it's this one. I mean, he took a freighted case, right? It was so loaded and could easily have been a 5-4 decision. And he managed to craft a decision that pleased enough of these guys that he really brought people together. And I think on a fairly reasonable compromise. I mean, just to put my own feelings out there, this does not seem like an unreasonable compromise to me. If you look at the substance of this decision, he said, look, the president still has to deal with these subpoenas. He's not immune from them, but we need to be careful because there is the possibility that the presidency could be sort of jerked around by Congress if we don't put some real boundaries around this congressional subpoena authority. So we want the courts to look carefully. Are these subpoenas crafted narrowly enough? Are they so that they're not fishing expeditions? They're not crafted to just grab as much stuff as you possibly can. Are the materials really necessary for the stated legislative purpose, or is the legislative purpose really just window dressing for an effort to harass the president? These are not unreasonable questions, because the shoe will be on the other foot at some point. The shoe may be on another foot in 6 months. It's not hard to imagine that, say, President Biden is inaugurated on January 20th, but there is a Republican Senate still, and that the Republican Senate is issuing subpoenas just like this. You could find that the press commentary looks very different in the beginning of February than it does right now. I think that the justices, these 7 justices led by the Chief Justice, really took cognizance of that fact, right, and tried to craft a decision that is aware that the shoe will be on the other foot at some point. And so this is, I don't know, call me crazy, call me credulous, but seemed like a pretty balanced decision to me. Not that it can't be misused, not that it, because I think that you could probably litigate a lot of these subpoenas to death going forward. If the courts want to allow that they probably can. But I think they put some reasonable limits around things. So I see the glass here as sort of half full, that a flat out win for Congress, any subpoena you want is fine. That was probably an overreach. President completely immune from subpoenas, that's an overreach. This seems kind of reasonable to me. So is this the Roberts victory? Well, yeah, I don't think that's an unreasonable view of it.
Well, it sounds like what you're saying, Joe, is that if we take President Trump out of the equation here and make the context not about him, did the court get to a decision that serves the country well for years to come, in 10 years, in 20 years? Will we look back and say, yeah, they got this right? And it sounds like you're saying they did.
I think that time will tell is the honest answer to that question, right? Because if it turns out that what we've done is allowed presidents to litigate every subpoena to death, and that it has effectively made it impossible to subpoena the president, well, that could still turn out to be the case. That would be disappointing, and then maybe this was not a great decision ultimately. But if the lower courts are reasonable about how they applied the standards, which are fairly vague, to be honest, but if they're reasonable about how they apply the standards set out in this decision, then I think that this is reasonable. And there's no easy way to draw these lines. And that lines need to be drawn, and then the lines need to be respected and enforced. And how that plays out is an open question. But I think as an early effort, as an effort to draw those lines as a start, this is not unreasonable. We just don't know. We just can't really know how it will play out in the end.
Joe, there's one more congressional subpoena that is looming out there on the horizon. It was not before the Supreme Court in either of these cases, but is getting a lot of people's attention. And my thinking is that it might even stand on firmer ground legally than the congressional subpoenas that were before the court. I'm talking, of course, about the ones from the House Ways and Means Committee.
I wish that case had moved faster. And I'm not entirely clear on why it didn't move faster, except that the Ways and Means Committee did not seem especially hurried in pursuing it. And I'm not sure why exactly. But it does seem to me that the Ways and Means Committee has a pretty solid case. The law that they are relying on for access to presidential tax returns is different than the law that these other subpoenas are based upon. In this case, the Ways and Means Committee has clear statutory authority to request tax returns for really any reason that the committee wants them. It's not clear that the committee has to specify why they want them in the first place. The law seems to suggest that they just have to ask, and they don't have to provide any reason whatsoever. And that the Treasury does not necessarily have any latitude about whether to respond to that request or not, that they simply shall provide those returns to the committee when they are requested. So I think on one, just to begin with, it's a pretty solid case to make that all the committee has to do is say, give me the returns, and the Treasury has to provide them. And then the Ways and Means Committee has anyway provided an argument for why they need these returns, offered a legislative purpose for why they need them, which I think is also extremely compelling. They say we need to look at these returns because we want to evaluate how well the IRS's audit process is for presidential tax returns. The IRS has a process under which they routinely audit presidents and vice presidents every year. They've done this since Jimmy Carter was president. And the Ways and Means Committee says, okay, well, we want to check up on this. We want to see if these audits are any good. And that's a pretty reasonable question, because the last time we took a look at the way the IRS was auditing a president, and we actually let someone look over the shoulder of the IRS and see if they were doing a good job, was under President Nixon. And it turned out that the IRS was doing a terrible job of auditing the president, that they actually were missing a lot of things to the tune of like $500,000 for President Nixon, which was a lot of money in 1973. So there are reasons to believe that the IRS is not especially good at auditing the person who supervises that agency. They're auditing their boss. So I think if Ways and Means is a little worried and says, gee, we're not so sure the IRS is going to be good at this, that's a completely reasonable question. History would suggest that they have reason to be suspicious. And so that they want to look at these returns, at President Trump's returns in this case, then to make sure that they've been audited correctly, I think that that's reasonable. Now, there are all sorts of arguments that have been made about why did you ask for President Trump's returns and not other presidents' returns, and why did you only ask for these specific years, and blah, blah, blah. There are arguments to be made about the specific subpoena in question. But the larger issue here is the legislative purpose legitimate? Are presidential returns relevant to that legislative purpose? I think that is a very clear case. I don't think that the Ways and Means Committee should have any trouble making that case. They should probably issue a lot more subpoenas if they need them for other presidential tax returns from President Trump and others. But this specific request seems entirely reasonable to me. I can't understand why they won't pursue it more zealously, but they haven't. So it's unfortunate, and that this is not one of the cases that got brought along faster. Eventually, it may end up before the Supreme Court. There are different issues at play here, but it probably won't happen before the election. So, the whole thing may be moot after that.
Looking forward, Joe, if you believe that transparency is important in this area, and you would like to see presidents being or as candidates being compelled to disclose their tax returns, how do we get to that point?
Well, I propose that we try to take some of the politics out of this by putting legislation forward right now that says, let's make presidential tax return disclosure mandatory for every president after President Trump. Let's exempt President Trump, because the issues here are more important than just President Trump. Some people hate him, some people love him, whatever, but I don't want to make it about President Trump because it is an issue of governance. It's not just about whether or not he's a good president or not, whether he should be in office or whatever. That, to me, that's very frustrating when it becomes an argument about how can we get rid of President Trump or how can we reelect him. I would be happy to trade that. I would be happy to say, let's take him out of the picture and say simply every president elected after President Trump, this would be required. And what I would simply say is we require financial disclosure of these of presidents and candidates already. I think Congress should reevaluate whether the disclosure we require is adequate. Maybe we need different kinds of financial disclosure. I'm not an expert in financial disclosure generally. But as part of that, I think we should also require that they disclose their tax returns. And the reason for that is that I don't believe that ultimately we can really rely on the IRS to audit the president's tax returns. I just think that the president of the United States is two things. He's the taxpayer in chief because he's paying taxes just like the rest of us. He's also the tax collector in chief. And you can't actually believe that the president is going to audit his own taxes, which is really how it plays out here, adequately. So as I just think that the only solution that really works for me in the long run is that the president releases his tax returns publicly, at which point they are essentially being crowdsourced. The audit is being crowdsourced. Now that's a painful sort of audit for anyone, I get that, but I think that that's the only way to really resolve this. I mean, other people have other ideas. They have some idea that like you give it to the Joint Committee on Taxation and then they look at it, whatever. I think the best way to do it is sunlight. I mean, Tax Analyst has been about this for 50 years. And if you release presidential tax returns to the public, then the public will audit those returns together in a crowdsourced process, and we will know to a certainty that the president is complying with their responsibilities as the taxpayer in chief. I think that's what we should require. I know that will be painful for presidents. I'm pretty sure that they can suck it up. I'm pretty sure that the job is attractive enough to them that they will still run for president.
Sounds like a good idea to me, Joe. Before we sign off, I just wanted to mention that in addition to the many hats you wear at Tax Notes, you also happen to be the curator of the Tax History Project, which is where members of the public can go and find past presidential returns and related materials, correct?
It sure is. We have presidential tax returns going back as far as, I think they go back as far as Franklin Roosevelt right now. I hope to get Woodrow Wilson's up there pretty soon. But then we have every president from Richard Nixon on. So we got a lot of them.
All right, and you can find the Tax History Project through the Tax Notes website. Joe, thank you very much for enlightening us on these issues. It's certainly been an interesting term for the Supreme Court, and maybe a bit notable that they decided to wind up with the big tax case.
Yeah. Well, pleasure to be here. Thanks for having me.
Bye-bye.